state wants to detain for 14 days. The state has not mentioned anywhere the fourth respondent in the supporting affidavit. Indeed, they wanted 14 days. They put out 14 days. Their next charge and ammunition they want to investigate on. To Your Honor. Thank you. They want to investigate him on B in possession of a firearm without a certificate. No inventory to that effect. D, Your Honor, it is in possession of government stores. Nothing was recovered, and there is no inventory to that effect.
That is why it is not even there.
Lastly, Your Honor, they want to investigate him of a conspiracy to commit a felony. Nothing was recovered from him to support that he had an intention to commit a felony. And that is why the investigating officer has not sworn on oath in the supporting affidavit to link the fourth respondent to anything he's investigating. The fourth respondent is a chief inspector of police. Designated as an armorer job description is to repair guns. For Cliff to know, simple, he's a mechanic of guns. Spoiled guns which can't fire are taken to him to repair. He does not at any one time receive a gun that is alive. He receives spoiled guns from the whole country. You know where he is detained now? At Capitol Hill Police Station. The OCS will send 2 spoiled guns to him. He will repair those guns are returned to that OCS. And I wanted to distinguish an armorer and the one called an armory, in charge of an armory. An officer called in charge of an armory he's in possession of proper functioning guns and proper functioning live ammunition at his disposal. Logically, that's the one who can sell guns. Respondent can only be charged of selling spare parts. Paragraph Your Honor, on the 25th day of September 2025, this date is critical. The 4th respondent was issued with a notice to compel attendance. By one John Kiragu for the OC DCI Operation Support Unit. There was no report about this investigation.
The report is dated copy. Copy number 2, 26 of
The
June.
OB that resulted on his arrest
Is OB number 2.
is OB number 2 and 52 of 26th September 2025. 2025. A day after the officer had been issued with this summons. As a law-abiding police officer, he reported on the 26th of September 2025 before the investigator. The investigator extended the compulsion to attend to 29th of September 2025 at 08 hours. And the officer signed. The fourth respondent walked himself and was locked up. A clear indication that is a law-abiding citizen and an officer ready to comply. Based on those facts, Your Honor, I have instructions to make an application for the fourth respondent to be released on cash bail and in the alternative bond. Your Honor, the basis I've laid clearly demonstrates a person that will be ready to comply of this court. Your Honor, all the inventories presented before you there is none specific to him. And the reason is now coming. You know, when a search was done in his house, Kenya shillings, 550,000 shillings. Kenya shillings, 550,000 shillings was taken from his home. This being the school fees, Shadrach will bring out the amount was for a child who is supposed to go to school, to university. You know, we have laid enough basis to consider the application, and Shadrach will lay the law and the facts to support.
Ati?
Thank you, Your Honor. With your permission.
Eh?
Yes, Your Honor. Thank you. I'll borrow a leaf from him. Your Honor, if it pleases you, for the record, my name is Wamboi, Shadrach Wamboi. I appear alongside my learned sister, my learned seniors for the fourth respondent. Your Honor, I will choose to be brief. And at the outset, Your Honor, permit me to mention that the application that lies before court is a serious application with very serious ramifications. Serious ramifications, for one, Your Honor, for the life of the fourth respondent hangs on a balance. His employment, Your Honor, is at stake, and his reputation and that of his family is equally in jeopardy. For the foregoing, Your Honor, this honorable court is invited to exercise great caution to come up with a decision on whether or not to permit the pre-trial detention of the fourth respondent. Your Honor, as counsel that has practiced such applications before, I am glad that the court has not been invited to walk down a path that has not been walked by previous courts. Stated differently, Your Honor, this application is not novel. And as such, Your Honor, you are invited to apply principles that have been set previously so that, Your Honor, we accord the fourth respondent great care we accord him great care, Your Honor, protection, and the prevention against any violation of his rights and fundamental freedoms. Your Honor, in the authority I have shared with the court, that of Oscar Sudi Kipchumba versus the Republic, criminal case number 208 of 2020. It's one of the authorities I have shared, but that is one that I will want to lay emphasis on. Your Honor, this court is only permitted to allow such an application Your Honor, it is only permitted to allow such an application when it has been demonstrated by the state Your Honor, I make reference to the counsel for the prosecution, that the detention of the fourth respondent is less restrictive measure. In other words, it must be the last resort to seek to detain someone before he can properly be informed of the charges that he faces and in any event, Your Honor, before he can be convicted of any charge. Your Honor, my senior, Mr. Dunstan Omari, has made reference to a notice to compel attendance dated the 25th day of September 2025. And Your Honor, I will pray that you also take a glimpse of it. That document, Your Honor, is proof that our client, knowing too well that he was required to assist in the investigations, attended those sermons on the 26th day of September. Your Honor, behind that notice is the writing of the investigating officer in a blue pen. Extending those sermons to a later date, which is today. Granted, Your Honor, from the 25th day of September 2025 to today, our client had enough opportunity, if he so desired, to interfere with witnesses, to run away from the jurisdiction of this country, to hide exhibit, but he chose not to do that. Begs the question, Your Honor, why at this juncture you will be applying to detain him for 14 days? No reference to him has been made in the supporting affidavit. Appears that he was just squeezed in as a respondent in these proceedings. Your Honor, to be fair to the investigating officer, Mr. Hilary Kimuyu, he has not found any cause to justify why the fourth respondent should be detained for 14 days. Your Honor, it's clear that the application, as far as the fourth respondent is concerned, has not been made in good faith, and it is meant to achieve another ulterior motive or purpose. As a consequence, Your Honor, and in the name of paragraph 24 of the Oscar Sudi case, that application should fail. We urge the court, Your Honor, to to disallow the invitation to detain our client for 14 days. In closing, Your Honor, I must equally urge that even, Your Honor, while you might look at my client on the face value to find that he is fit and proper, Your Honor, my client is a sick man. He has been unwell since the year 2021 after he suffered COVID-19. He has had chest problems and under a doctor's supervision for at least every fortnight he must visit the hospital. Over and above that, Your Honor, he suffers from serious and acute ulcers. He even walks with his medication. He can show you. He has his medication with him. For the purpose of the court record, Your Honor, he has even produced a number of tablets that he must use quite often. For that reason, Your Honor, it will be inhumane to detain an innocent and sick suspect, Your Honor. I urge that you find in favor of our application for bail, permit him to join the rest of his family. I rest, Your Honor.
I've learned to regulate my speed.
You should pay me, I taught you
Yes.
to talk slowly.
Now it is next. Let me start by asking whether the police and the state have come here with clean hands. More so the police. They want you to detain for 14 days. These respondents but the first thing they do is when we go to the station, they deny the accused person and the lawyers the right to talk to the respondent. And ask for 14 days. The question then is simple. Can you trust the respondents in their hands for 14 days. Say that you cannot in that answer. Let me now indicate why this application must fail, what the state needed to prove. They needed to prove that the fourth respondent does not have a fixed abode. What contradicts that is they did a search in his house, so he has a fixed abode. They needed to prove to this court that not only to say that he will interfere with witnesses, that he actually has interfered with witnesses. In the case of which the authority have provided, of Dwight Sagarai versus Republic, High Court case number 61 of 2012. In page number 4. Third paragraph. What does the court say? And I'll read that part only. For the prosecution to succeed in persuading the court on this criteria, however, it must place material before the court which demonstrates actual or perceived interference. Actual or perceived interference. Yes, I've given it. It must show the court, for example, yes.
Let the court have it first.
You know, we have supplied all copies.
Dwight Sagarai, number 61 of 20.
You know, we have an extra copy. We can still share.
Yes. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and the witnesses. Just to remind the court, we don't know who the witnesses are. For the prosecution to prove to the court that the fourth respondent is a flight risk, They must place material before the court. The case of Richard Alden versus Republic. High Court case number 48 of 2016. Before Justice Lassit, as she then was. What did the court say? For the prosecution to even say a person is a flight risk, must place material that the person has attempted to flee, has made arrangements to travel, or has bought something like a ticket. Material that can be verified. In the absence of that material, the court is left to speculate or imagine. And we are here for facts, not imagination. And Your Honor, if in these two instances of flight risk and interfering with witnesses have failed as they have right now, they remain with one thing. Issues of national security. Your Honor, in the authority of Dwight Sagarai, it is clear, the court have said, in matters of national security, yes, yes, or national interest, or public interest, it becomes the burden of the state to place material before the court to show how the respondent has interfered with matters of national security, when, where, and how. so that again the court does not enter into the realm of speculation. You know, then it is now why I must then refer back to the issue of the compelling of attendance that you have been given. The police grant the fourth respondent an attendance document. He does not fail to attend. Otherwise, they would have said it. The antecedents that we usually talk about, isn't this a good case, Your Honor? But today they come and tell you, denying bail for the next 14 days. And this is why Article 19, Your Honor, is very good for the respondent. It is very clear in Article 19. The fundamental rights provided for belong to an individual, not the state. And therefore, they cannot blow hot and cold on this fundamental right. And Your Honor, the reason why these fundamental rights exist is to prevent the fourth respondent suffering what he is going to suffer and to save him from such excesses that the state is demonstrating. You know, now the fourth respondent, he has become a ward of this court. So how do we rope you in? You know, Article 20 and 21 are very clear that these fundamental rights must be observed by the state, the court, the police, and any other organs. And therefore the court must start by wanting to ensure that the respondent enjoys these fundamental rights. Start by wanting to ensure. So we have noticed that the state does not want this to happen. Yes. Yes. So we have noticed that the state does not want to ensure that we get these fundamental rights. We come then under Article 22 and ask the court to ensure that the of the respondent are fulfilled and enjoyed. The state then comes and tells you, these are persons who are police officers and in authority. Do not give them bond. How does that work with Article 25, where you're not supposed to discriminate against any person? How does that work? That should also open Article 27. Same thing. As I sit down, Your Honor. I will also ask you to look at Article 28. Whereby the dignity of an individual is an integral part of him. It must be preserved. The fourth respondent has not been charged yet. And eventually may not be charged. And that is what we pray, because there is nothing on him. At least, Your Honor, maintain his dignity, grant him bond. Give conditions that you want, Your Honor, to ensure that he appears on whichever day the court may wish. On the number of times the court may wish. On the type of security the court may wish. So that with dignity, as the investigations go on, he can come to court. That is all.
That's all.
Afternoon.
Yes, Your Honor. And I have witnesses, I don't know.